Yeah, good afternoon, everybody. We have the first of the panel discussion that is on the viewpoints on digital evidence. Well, before I start this session, I would just like to introduce the panelists. On my left, we have Ms. Sandhya Dokhe, the principal from Siddharth Law College. On my first right, I have Dr. Ashok Yende, the founder managing partner of Yende Legal Associates. And to his right, you have Smith Gonsalves, director and principal consultant of Cybersmith Secure. I'm sure that he will touch upon some of the technical aspects of digital evidence. And to his right, I have my another close friend, Dr. Anuj Agarwal, who happens to be the chairman, Center for Research, and who works very, very closely with the law enforcement agency in the northern part of our country. Well, to begin with, my name is Dr. Harold DeCosta, and I also work with the law enforcement as well as with the judicial agencies of the country in terms of matters related to cybercrime investigation, cyber law, and digital evidence. So since I've got such a esteemed panel with me, before I actually start with rolling out the ball on talking about this viewpoint on digital evidence, let me tell you, in the last couple of years, in the COVID era, we have seen a lot of cyber crimes which have taken place. But most of these cyber crimes, what have been registered, we have yet to get the criminals caught on a major cases. If I have to share you some of the statistics, between 2017 to 2021, in 5 years, Gujarat recorded almost about 4,700 cybercrime matters. FIRs were registered in almost 4,700 cases. In half of them, the charge sheets were filed, but the conviction was zero. In Karnataka, we had almost about 39,900 odd cybercrime cases registered in the last 5 years. Half of them got converted into charge sheets were filed, and the conviction was only in 21 cases. What I mean to say is to tell you about that why these convictions are poor. Well, the convictions are more, that doesn't mean the investigations are proper. It also can give a side view story that how right we are in having the complaints to be registered, investigation, and the legal evidential point of view, how that evidence was proven in the court, such as the conviction was being given. I'll start up first of my question with my friend Dr. Anuj Agarwal, and I would like to have his opinion that what he feels about the digital evidence in today's modern world. Anuj.
गुड आफ्टरनून, नमस्कार। लंच के बाद का सेशन सबसे मुश्किल होता है। अगर खाना बहुत अच्छा बना है तो ऑडियंस सुनने की स्थिति में नहीं है, और अगर खाना ख़राब है तो स्पीकर बोलने की स्थिति में नहीं है, क्योंकि बहुत कठिन सवाल पूछे जाएंगे उससे। तो ये सेशन सबसे मुश्किल है, और उसमें मुझे सबसे पहले बोलने के लिए कहा गया है। और चेयरमैन ऑफ द सेशन ने ये भी कहा कि वो मेरे मित्र हैं। भाई, ये किस प्रकार की मित्रता है? खैर, अब उन्होंने चूंकि कह दिया है तो मैं कुछ कर नहीं सकता। देखिए, डिजिटल एविडेंस केवल साइबर क्राइम में ज़रूरी नहीं है। आज कोई भी क्राइम हो रहा है, सो कॉल्ड ट्रेडिशनल क्राइम जिसे हम कह सकते हैं, या साइबर क्राइम, एविडेंस तो डिजिटली मिलेगा। फिजिकल एविडेंस अब कहाँ मिलेगा और कौन उसे लेता है? अगर आपके गली मोहल्ले में चेन स्नैचिंग बहुत ही कॉमन टाइप का क्राइम है, तो उसके लिए एविडेंस क्या है? कि जो सीसीटीवी लगे हुए हैं, या अगर कोई वहाँ से निकल रहा है, उसने किसी तरह का मोबाइल में वीडियो या फ़ोटो खींच लिया है। अगर बैंक में कोई क्राइम हो रहा है तो भी सीसीटीवी में ढूंढेंगे सबसे पहले। फिर क्रिमिनल्स की लोकेशन ढूंढने के लिए मोबाइल लोकेशन पे ढूंढेंगे। यूरोप में ओवरऑल एविडेंस 60 से 70% डिजिटल ऑलरेडी हो चुका है। हमारे यहाँ भी स्थिति वही है. The only problem is that our agencies as well as judiciary will take some more time to become used to, because this is something technical in nature, digital in nature, and they are not well equipped. अभी अगर आप किसी से पूछें फराडे बैग, क्योंकि कहते हैं भाई डिजिटल एविडेंस मोबाइल फ़ोन वगैरह फराडे बैग में रखना चाहिए, वो कहते हैं साहब कागज़ और पॉलीथीन के बैग तो अवेलेबल नहीं हो पाए, वो तो हम लोग इधर उधर से उठाते हैं, ढाबे से उठा लेते हैं, कहीं से उठा लेते हैं, तो ये फराडे बैग कहाँ से मिलेगा और ये होता क्या है. सो आई थिंक अवेयरनेस की भी कमी है और रिसोर्सेज की भी कमी है, और जो सबसे बड़ी एक इशू है, और हमारे यहाँ एक कल्चर है जिसे हम कहते हैं चलता है, बोले सब हो जाएगा चिंता मत करो. 5 साल बाद तो वैसे भी जब ट्रायल पर आएगा तो ना मोबाइल काम कर रहा होगा ना कोई चीज़ काम कर रही होगी, उसे कैसे भी रख दो. बट लेट मी रिमाइंड यू दैट इन डेज अहेड the evidence would be majorly digital in nature, whether we like it or not. And this is good also, because digital evidence is very close to a scientific and document, both important things. It is less of a hearsay. You just can't change a digital evidence as per the wishes of either party. So this is one of the best evidence, if available, for a sure conviction, and it is in the benefit of the accused as well as the victim.
Thank you. Anuj ji, आपने तो you started rolling the ball in saying about that digital evidence is not only a matter related to cyber crime, but it's also a part of the other traditional crimes also. So well said. Smith, I would like to get your viewpoint from a little technical perspective. That what do you think digital evidence in terms of the corporates or an industry, how vulnerable they are?
Well, you have highlighted a very, very important point. Let me tell you that first. And what I think, so what I have seen, not I think I would say, what I have seen with most of the corporates is that I see a lot amount of steps, initiatives taken by the government, and a lot amount of things done in terms of helping organizations to quickly respond when an incident has happened. So I look at the both the ends. One is from the law enforcement perspective, where we help them advise, and from the corporates, where they have to mature their overall infrastructures. So right now, if you see, there is this certain guideline which has come in 6 hours reporting, if you see. Now, for any incident that happens, a biggest challenge I see with most of the corporates, and in corporates, we are dealing with the number one attack vector, and that is called as ransomware. I'm sure everyone is aware of that. And in that scenario, when such a sort of a ransomware attack happens, your log servers are the number one which are quite important to know from where what has happened. The worst part is that the log servers that needs to be maintained by the corporates are not being maintained. The business continuity planning, the tabletop exercises, and looking after whether which particular log servers are connected, are you ensuring that you're storing the logs for 180 days to 360 days is not being done. These are certain specific gaps in which, while investigating, while analyzing, you are not able to specifically correlate, which gives a lot amount of information not being channelized properly. Example, let's say a malware is coming in from a browser. Let's say someone clicks on a URL, the attachment gets downloaded. Now the attachment gets downloaded. Nowadays, one more thing what I have seen is, these malwares which come in, they target your Active Directory, domain controllers. So what happens is, earlier, what we used to do is, when we used to do certain sort of, we used to use various logging tools to do incident response, to see what sort of logs have been shared, the syslog servers and all. Nowadays, what is happening is, the agent, once it gets downloaded, it is behaving like a pen tester. It is going and scanning your network. It is doing reconnaissance, and it is using different attacks like golden ticket or silver ticket, and getting to your domain controller. With domain controller, it disables your antivirus, and then it uploads a ransomware agent and deletes all your logs. So your log server, AD log server fails. Your firewall is the one point which you are basically able to have in. And then when we come in to investigate, when we try to do DFIR, We are simply left with the machines where we take images and then we are able to see the logs that are basically coming up with tools from FireEye and so open source tools especially. So what happens all the time is the accurate logs from what was the vulnerability through which the attacker came in, what internally the attacker used the vulnerability for lateral movement is unknown. These points create a lot amount of concerns, and I believe this sort of evidences are quite critical for an enterprise as a CISO, as a CIO, that what is a specific gap that from a MITRE, ATT and CK point of view, he should be bridging in. So that's my take. Yeah.
Okay. I think Smith has covered about the point about the cybersecurity breaches. And what he rightly said across was that the breaches are too many. If the log sheets are being deleted from the system, then you don't have any more evidence as how that crime has been orchestrated, how that digital footprints which are not there, how exactly you can go ahead in a prosecution of a case. Okay. Well, before I ask the next question to Dr. Yende, who happens to be one of a very seasoned professional in the field of law, and he has been the former director of law of Mumbai University also. So, sir, I just want to ask you a very important question. I happen to just get a WhatsApp message from Deepak. I hope that Deepak is there. Yes. Oh, yeah. I happen to get a message, Deepak, a WhatsApp message from you at 10:54 a.m. today, and you said to me that the Cyber and Data Security Summit is cancelled. Kindly take note of the same. And I replied back to you, okay. That's the digital evidence with me, and I'm sure that Deepak will say that he has never sent this WhatsApp to me. I want to have the attention to be attracted to a point that we say that a man can lie, but a document cannot lie. Sir, I want your opinion on this.
So actually more or it's a technical issues are involved than the legal issues. And you know that probably everybody is aware that the conviction rate is only 1% in India particularly, though government is trying best. And there are many reasons actually why there is a poor conviction rate in this particular digital evidence cases like that. So there are very few cases before the Supreme Court. I will just go beyond your question. Like Basir's case was there. In Basir's case 2004 was there. Then earlier also this Suhas Kitty case was there 2004. And then all these cases were overruled by the Supreme Court. In the recent case of 2020, where from Ahmednagar, one case was there regarding digital evidence. So all these issues are so complex, and my learned members and panelists, they just mention about the technical things, and you are there who is training the judges also, I think, training the judges. So you understand that there are not only legal issues which are involved, but there are many technical issues which are involved. And what happened there, the entire system, for in India what happens, we enact the law, we pass the law, and then there are so many inadequacies in the system. Inadequacies in the terms of the infrastructure, inadequacy in terms of the expertise in that case. Now the police station people don't know anything about that. They don't know, they are not aware. There are hardly any police station which are specialized in the cyber forensic, and to my knowledge, if Dr. De Costa can correct me, there are in Tamil Nadu 46 specialized police stations are there, Maharashtra 43 are there, and there are 11 states there no police station deals specially with the cyber crime, cyber forensic. Now you think the situation where law is there, no enforcement machine is there. Law is there, enforcement machine is not aware about anything. Then courts are there, judges are there, judicial system is there, they are not aware about that particular system. You can understand what will be the exact result of that particular system. So same thing happening, that many laws are coming, same thing is with the IT law. Information technology of 2000 has enacted, then so many lacunas were there, fortunately it was amended. Then Evidence Act was enacted, section 65B was introduced, where digital evidence was mentioned about in that particular section 65B. Then 79A Information Technology Act again was introduced, where there is a provision for appointment of the examiners. So, in spite of all these provisions, there are so many lacunas. The system is lacking behind in so many things. If law is there, machinery is not proper. justice delivery system is not proper. It is not proper in the sense they are not aware about the things. If now my friend DeCosta is training many officers and the judges also. I know. Why he is training the judges? Because they are also not aware about the situation. So enforcement machinery is lacking in infrastructure, in expertise. Justice delivery system is lacking about the knowledge about the system. Then they will be totally bound to be a failure of the system. And that's why law may be good like that. But along with the law, unless there is a this enforcement machine is proper, law cannot be meaningful. That is what I personally feel.
Yeah, okay. I think you have raked upon what are the deficiency. And if the investigation is proper, you mean to say that somewhere the judicial agency is not able to understand, vice versa, or in some of the cases, both the things are not working in tandem. Okay, we had, in the morning, we had the inaugural session by Advocate Pawan Duggal. And incidentally, there's a WhatsApp chat, what I've got from his number also to me. I'm sure Pawan is not there over here. What I want to say is that in the Indian Evidence Act, we have some provisions that, for example, Section 61, evidence can be produced either in primary form or in secondary form. Now, if I want to produce this evidence, what is there with me, where, Dr. Pawan Duggal, from his WhatsApp, from his number, I've got a message which says that, I'm sorry, I can't take up your matter. Now, this, if I produce in the court, this is nothing which is very cognizable or nothing. But if at all it was a cognizable, if it was something which was a threatening, I can just produce this message by taking a printout and make it presented in the court. I'm sure that the law enforcement agency, most of them, Anuj would agree with me, because he also assists a lot of law enforcement agency, that most of the time, the printout of any electronic message is deposed, and the police and the court believe it as a gospel truth. So under these circumstances, if I just produce this message, what Deepak sent a message to me that the session is cancelled, the conference is cancelled. So under this point of view, I think the time has come for us that a man can lie, but an electronic document also can lie. And I think the provisions as what we laid in the Evidence Act, I think has to be properly analyzed. I'll come back with that question in a little time from now, that how we can exactly ensure that any part of an electronic evidence, how to know that it is authentic, it is spoofed, so on and so forth. Well, I've been joined by another panelist also, Mr. Srinivas Kotni, who is the founder of Lexport. Okay, going ahead. I just want to ask a question now. Mr. Srinivas Kotni, you just happen to come now, and the first question I'll put up to you only. The conviction rate in India is very poor. What are your take on it?
Thank you so much, sir. First of all, I apologize for being a little late, Delhi traffic, Now, conviction rate is about 4%. I mean, we all know about that in cyber and these kinds of offenses. The reason is basically relating to technology, because the law enforcement agencies are generally not equipped enough with the technologies to unearth and try and get into the bottom of the crime. That apart, the perpetrators of crime also are always one up. I mean, they're up. They're always up at least a couple of notches in their ingenious ways to compromise the systems. This apart, there is also a general lethargy. I mean, I can recount the kind of grooming and training which is given to the enforcers is also responsible for that, because they are trained on the conventional investigation strategies and also the provisions of IPC which were linked to the physical world. Technology has, of course, we've been seeing technological transformations for the last 20, 25 years. But please stop me whenever, because I've got this habit, being a lawyer, to keep on, once the mic is given, we generally don't give up the mic. But these are the reasons which some of these reasons come to my mind immediately. So there has to be a full-fledged effort from all concerned, not only the legislation, but from the public also, to appreciate and give that kind of evidence, because you have secondary evidence, you have primary evidence. So if you leave the police officers, even the cyber cell for that matter, I mean, some of you may differ, because some of these young officers are very, very brilliant and they are doing their best. But at the end of the day, any investigation, any evidence gathering exercise is as good as the support which is received from all concerned, primarily by the complainant. Because technological issues are very, very difficult to understand and also fathom many a time. So therefore, that support infrastructure and support system has to be built. As a society, we have to come up and then deal with those situations to bring that 4% to 14%, then 40%, and like that. So conviction rates would definitely come up once because there's no escape. Today, most of the services, most of the trading, most of the goods are all online. And there are also banking transactions happening, insurance transactions happening, fintech transactions happening. All kinds of transactions are happening online, and it's a free play for the perpetrators of crime. They've got a new age mechanism to not even get out of their homes and then still steal your hard-earned money and also resources. So I think we all have to work together on this.
I think you banked upon two key takeaways. One is on the infrastructure, and the second is the awareness among the law enforcement agency. Because the law enforcement agency, unless and until they are not made to understand that how the evidence has to be collected, how the evidence has to be preserved, and how it has to be told in the court, such as the court shall appreciate it, we are going to have this problem of the conviction being poor and more poorer in the days to come, unless and until we don't start working right now and not waiting for days together for some certain provisions to come. Okay. My next question, I'll just put it across to Smith. Smith, we have a lot of issues as far as the corporate side is concerned. Now, since you are working in the industry, you are providing services to the industry. My question to you is that the industry is very unhappy. Whenever there is any cybersecurity breach, now you just said some time before that within 6 hours of they knowing it, they have to provide this information to the concerned agency. That's point number one. And point number two is that the corporates feel that if they have any complaint to be registered, tomorrow they will become a most popular figure in the media. Their information will come. Point number three, corporates feel that we have to go to the police stations every now and then, giving evidence, giving statements, so on and so forth. And last but not the least, as what Dr. Yende just said some time before, that it takes years together for the matter to be sorted out, either related to conviction or either related to the acquittal of the matter. Now, my question to you is a very simple one, but a very thought-provoking one. Do you think that today the industry should have its own internal team to investigate cyber crimes and have the matters to be investigated internally? And if they find that there is a solid digital evidence in place, then they can approach the law enforcement agency? What's your take on that?
Well, I can say I can partially agree with you that that the corporate should have their in-house security team. Probably they can create it or probably outsource it to organizations. But it is important that they have one which continuously does DFIR, Digital Forensic Incident Response and Threat Hunting. Because what I am able to see today with corporates is that we are bundled up with a lot amount of variety of products, which is good. We have been talking about zero trust, we have been talking about network segmentations, and then we have been talking about the different drills, red teaming and all. But there is a concept called as purple teaming, in which you have a combination of attacking and the defending team. What I believe is that the corporates should focus on creating a team which works on the top 5 or 10 use cases, the threat attack vectors that are important, and those the likelihood of those occurring is high based on the risk indicators. And whenever those happen, they are already prepared to ensure that first priority is that the systems are restored, systems are getting back to the business. And second is that to ensure that whatever were the traces of the IPs, the logs, the particular IOCs, indicator of compromise, which we call in, were able to be documented and then well positioned forward to the NCI IPC or to the nearest cyber cell, or basically to the I4C, the cybercrime.gov.in, where they can report it. So it needs to be done parallelly. But for this, the problems that corporates see is budgets. And second, as you rightly pointed, they fear to go ahead and report an incident. It is for the fact that they think their business or the value of their stock would be affecting, but they aren't able to think that if the data of the citizens is leaked, any which ways, whenever the attacker is going to put certain amount of negotiations on the dark web or so, it's already going to come into the media. So it's important for them to know whether they take a stand and give the certainty of the situation or try to avoid it. This is what I personally feel. Second, I see law enforcement agencies supporting it, supporting organization. There is this myth in the organizations that I want to clear probably is, people think that if you report incidents to law enforcement agencies, the news will come to media. No. I have worked with law enforcement agencies, I have advised them. And what I have seen is, when incidents are reported, they ensure that they help the organization to recover out of it, and proper judicially steps are taken up. But the sort of an amplification of the particular thing that is happening is being ensured that there is no disinformation being spread across the particular thing. So that is what I'm able to analyze. So that is also being said, that I would also like to make one more statement. One more myth in corporates is that we have SOC. We have SOC and we are sorted. Trust me, SOC is going to help you to monitor incidents. It's going to give you visibility. But during the time of crisis, I have been with few of the organizations who have faced incidents, and we have been there throughout the night helping them. What I've realized is it's not the SOC team who's only going to be there, because SOC team is going to monitor and alert incidents. But trust me, chances when a real attack happens, chances of SOC team missing the information is certainly going to be there. You know why? Because SOC team is going to rely on the IOCs raised by the tools. What are those tools? Those are your SIM, endpoint, EDR, XDR, firewall. Now if a successful attack, if it comes in, when a successful attack happens, these technologies are basically bypassed. And if these technologies are bypassed, what is the SOC team going to do? So you need to have a proactive team which does the reconnaissance and incident response. And at the end, I will just conclude it in this line, that organizations also have to see the number of attacks that cybersecurity team are able to save. But it just takes one attack to basically get the entire mess around. Yep.
Okay. I think if I just to take one singular point from what Smith said, is that you require both. You require the internal team also to be in the place, as well as you require the law enforcement agency. The reason behind is that because the internal team would be in a position to collect the evidence, but they will not be able to how that evidence to be preserved, and of course they'll not be able to tell in the court that how the evidence has to be appreciated. So you require the law enforcement agency in tandem with the industry's internal team also in place to be there. Because if you leave this for the law enforcement agencies to collect the evidence, I'm sure that there may be a lot of errors, because most of them are not well pruned as how the evidences has to be collected. My question to you, Dr. Yende, is that what's your take on this? Do you really think that you require a forensic team to be there? Yes.
Yeah, I fully agree, because if you rely purely on public enforcement machinery, there will be total failure. Because our police machinery has so many multiple tasks. You understand what I mean to say. They are not, and they don't have specialized police stations. Just now I mentioned only few of the states have specialized police stations. So I feel, and they don't know about all these things. Like recently, I was just mentioning Arun Khotka's case, 2022 Supreme Court. 3 judges bench of the Supreme Court said, there's this, rightly told by my friend Dr. DeCosta, that secondary evidence is not admissible. And that's why WhatsApp chats have not been, don't have the evidentiary value. That is what Supreme Court said. Initially, there was a lot of confusion in buses and other cases, whether you just send the WhatsApp chat, copy it, paste it, just now Dr. DeCosta has sent the message. So that copying and pasting and sending the messages called as secondary evidence, it has no evidentiary value unless it is corroborated by the expert evidence. That is very interesting and very important decision given by the Supreme Court in Arun Khotkar's case 2022. Otherwise, there would have been a lot of problem even for the corporates. Anybody would have managed, anybody can manage the messages, send the message from here and there would have been a lot of penal consequences to the corporate people. You understand that many people are in jails. Many people are in jail because of the false evidences. So this digital evidence is a very important sector, even applicable to the corporate sector, because otherwise entire corporate will be collapsed.
Yes. I think that the case law of Arjun Khotkar was one of the landmark judgment. I think each and every one should go through it as what the Supreme Court has observed in terms of the digital evidence. And as rightly said, that secondary evidence doesn't have any evidential value unless and until it is corroborated with something else. It's very, very right. And it's now been, this is one of the landmark case which has been told across in many of the forums, even in the National Conference of the Judges. This is a landmark case where it has been
What
taken
happened,
out.
sir? It has overruled earlier Supreme Court cases.
Yes.
So earlier Supreme Court cases were
Yes.
wrongly decided.
Yes,
And
absolutely.
they specifically observed that they were per increments, they were wrongly decided.
Yes.
And the Supreme Court itself decided wrongly decided earlier cases.
Yes, absolutely right. Yes, I'll go back to my friend Anuj. Anuj, there are a lot of crimes which are taking place, and as what we have about it is we have heard about the term, that is the forensic accounting. And when we talk about forensic accounting, we talk about some corporate breaches, financial breaches. So what's your take on this? How the forensic accounting can change the dynamic of the industry or the nation as a whole?
Very interesting debate going on. In days ahead, we will have more and more of economic offenses and less of physical offenses. I met few law enforcement officials and they were boasting the crime rate in our area has gone down. And they were feeling great about themselves. I said, no, sorry, it is not because of you. Then said, what is the reason? I say, people are not interested in street crime anymore. अभी चेन स्नैचिंग के लिए कितना मुश्किल काम है. सबसे पहले 2 लड़के इकट्ठे करो, फिर कहीं से बाइक उठाओ, उसमें पेट्रोल डलवाओ, पीछे बैठने वाला लड़का अपने पैसे पहले मांगता है. वो कहता है भाई मुझे तो कोई मतलब नहीं, चेन स्नैचिंग हो या ना हो, मेरे पैसे आप दे दो. फिर रिकॉनेसेंस करो, मैडम कब आती हैं स्कूल से, कितने बजे निकलती हैं, उनके साथ कौन होता है, वगैरह वगैरह. फाइनली डी डे आ गया, चेन स्नैच भी हो गई. चलो अभी लेकर थोड़ा आगे बढ़े. अगर किसी का अमिताभ बच्चन जाग गया, पकड़े गए, घर की सारी फ्रस्ट्रेशन, जैसे खाना अच्छा नहीं है, चलो भाई इसी को पीट देते हैं, क्योंकि यहाँ तो किसी को बोलने का फ़ायदा होगा नहीं. उसके बाद मान लो वहाँ से निकल गए, चेन नकली. So physical crime is going down because of these difficulties. And the other major reason is the cyber and economic offenses are so easy. You are just sitting in your air-conditioned room, calling up Mr. Mittal. सर आप इतने बड़े आदमी हैं, खुश हो गए. बड़े आदमी हैं फॉर श्योर, मर्सिडीज़ में चलते हैं. इधर उधर की बात की, सर आज आपके लिए डिनर सेट किया है. आपको पता है इस समय नंबर 1 पे कौन चल रही है अभिनेत्री. कार्ड भी आपको फ्री मिल रहा है. 4 कार्ड हैं इनके पास ऑलरेडी, चारों फ्री हैं. लेकिन वो डाइनर जो बंद हो चुका है वो इन्हें और दिया जा रहा है. ले लेंगे, सारे लिंक्स पे क्लिक कर देंगे. सर प्लीज़ एक्सक्यूज़ मी, बीइंग फ्रेंड मैं आपको, सारे लिंक्स पे क्लिक कर देंगे. वो बोलेगा कि नहीं सर आपके पास तो आईफोन है, इस पर तो नहीं चलता है, ये केवल एंड्रॉयड पर चलता है, ये फॉर्म गवर्नमेंट की ऐसी रेगुलेशन है. मगर हम लड़का भेज रहे हैं आपके यहाँ, आपको कुछ करने की ज़रूरत नहीं, वो आएगा, इनकी चाय पिएगा, खाना खाएगा, भाभी जी को नमस्ते करेगा, पैर छुएगा, इनका सिम लेगा, अपने फ़ोन में डालेगा, क्रेडिट कार्ड की लिमिट बढ़ाएगा, 19 ट्रांजैक्शन करेगा, बढ़िया. So the pattern of crime is changing. Similarly, if you look at all the builders, पहले हमने पुरानी जब मूवीज़ देखते थे तो जो डकैत है ना, उसमें डकैत दिखाते थे, वो चंबल में रहते थे और उनकी एक पर्टिकुलर टाइप की वेशभूषा होती थी. आपने शोले वगैरह देखी होगी, है ना, देखने से पता चल जाता था कि ये गुंडे हैं, डकैत हैं. अभी वो लोग सिटीज़ में मूव कर गए हैं, यहीं कहीं बैठे हैं, मतलब यहाँ तो नहीं होंगे, साइबर कॉन्फ्रेंस चल रहा है, तो वो लोग अभी इधर मूव कर गए हैं. और पहले आप दिखाते थे कि भाई गांव में आप कोई सामान लेकर निकल रहे हैं तो वो उनका आदमी है, और शोले में आया, वो भाई काका अनाज की बोरियां रखवा दो वरना देख लेंगे तुम्हें, और उसने भगा दिया. अभी वो कुछ नहीं करते हैं. अभी उन्होंने एक ऐड निकाला, हम एक बिल्डिंग बना रहे हैं, आपको 4 कमरे का फ्लैट दे रहे हैं वगैरह वगैरह. आपने जाके उसको फॉर्म भर दिया और EMI अब आप बैंक को दे रहे हैं. उस शोले के जो हमारे नायक खलनायक थे उनको पैसा मिल गया है. अब वो सड़क पे कहीं दिखाई नहीं देंगे, अच्छे कपड़े पहनते हैं, टाई लगाते हैं, सूट पहनते हैं. सो व्हाट हैज़ हैपेंड ओवर ए पीरियड ऑफ टाइम इन द नेम ऑफ डेवलपमेंट, whether people have developed or not, the criminals have developed. And they have moved to sophisticated cyber and economic offenses. Now, after being cheated by these builders, people go to say court कि साहब ये हमारा एग्रीमेंट हुआ था, 3 साल में फ्लैट देने के लिए बोला था और अभी देते नहीं है. तो उसमें क्या एक क्लॉज होता है, वो क्या होता है, पेनाल्टी क्लॉज, कि भाई हम आपको पेनाल्टी देंगे. कोर्ट में पहुंच गए, कोर्ट ने कहा भाई इसमें तो कहीं लिखा नहीं है, आपके एग्रीमेंट में कहाँ लिखा है. कहते नहीं नहीं वो बोला था, ये पता नहीं, वो तो मार्केटिंग थी, इसमें कहीं नहीं है. सो जो अकाउंटिंग है, नाउ हाउ डू वी रियली फिगर आउट दीज क्रिमिनल्स, दीज वाइट कॉलर क्रिमिनल्स, थ्रू दी फॉरेंसिक अकाउंटिंग. दे हैव probably done all what they can do to cheat the people, but somewhere down the line where they fail, these criminals, because they are not expert in accounting and chartered accountants are not good, they don't hire good chartered accountants, they fail there. So forensic accounting is a very, very important, as you very rightly mentioned, important activity through which a lot of white collar criminals can be nabbed. And obviously, it is a good evidence. So that's the perspective.
Yes.
Back to.
I think it's a very good, interesting analogy what Anuj put across. He gave you through a filmy script and made you understand that cyber crimes are more easier to be done than the traditional crimes. You can sit in the AC in the comfort and in a suit boot. All of those could be, all those nuances in terms of the better privileges could be there for a criminal. And the chances of going in the jail is the least because the convictions are very poor in cybercrime. Okay. I'll just come to the next question. Madam, I just want to ask you, is that we have the provision of providing the electronic evidence to the law enforcement as well as to the court in terms of the section 65B. Can you just throw some light on how the evidence can be produced or how the evidence can be given to the law enforcement agency or to the court? Your say on this.
Thank you, sir. Actually, during 1950, electronic record was confined only to tape recording and videography. Electronic record has been admitted as evidence only after 2000 as procedure mentioned in section 65 of the Indian Evidence Act 1872 and made a certificate under the subsection of 4 of section 65B of Indian Evidence Act 1872. Now almost all the documents in the electronic record are admitted as electronic evidence, such as CCTV footage, ATM receipt, bank statements, e-form, government orders, digital signatures, etc. Now everyone is asking how should be the format of this 65B. The 65B format will be in similar kind of affidavit only, in that the person who is holding the legal control of mobile phone or any electronic device wherein said material is stored, said person shall issue a certificate of 65B4. The electronic record is produced, the particulars of devices in the production of that electronic record. The said certificate should be signed by the responsible official person who is in control of the device, and the legality of the production of record has to be shown. Now, in this, mostly, however, there were many conflicts regarding production of this certificate, and which was prevailed in certain judgment. I would take one after the another. In 2005, State NCT of Delhi versus Navjot Sandhu Afsan Guru, the Supreme Court held that a certificate under Section 65B4 is not necessary. An electronic device which can be adduced through Section 63 and 65 of Indian Evidence Act 1872. This view was overruled in Anwar PV versus PK Bashir and others in 2014, where Supreme Court held that Section 65A and 65B are code in itself, and procedure of those sections should be followed to adduce electronic evidence. Similarly, this was again overruled by SC in 2018 by Shafi Mohammed versus State of Himachal Pradesh, where it was held that 65A and 65B is only procedural and hence need not to be followed in all circumstances. Means there were some kind of circumstances where it was possible. Finally, this confusion was settled by a larger bench in Supreme Court in Arjun Panditrao Khotkar versus Kailash Kushanrao Gorantyal in 2020, which earlier DeCosta sir and Yende sir has mentioned that procedure under Section 65A and 65B is a code itself and overruled the general provision regarding admissibility of electronic evidence. Therefore, provision of 65A and 65B should be followed to adduce the electronic evidence. Thank you.
I'll just make in just half a minute the provisions very clear at what Madam has explicitly said from a legal perspective, is that if you don't want to submit your device in which there are some information or an evidence, then under that point of view, the information can be extracted from the device, copied into a pen drive or into a CD, and then it can be given. But the moment it has been copied, that evidence becomes secondary in nature. And to make that evidence once again primary in nature, you require a Section 65B certificate, which is nothing but an affidavit which has to be produced to the court along with the evidence which has been extracted from the primary device. But there are two main clauses. The one important clause is that the person who signs that certificate should be an official position as far as the device is concerned, or should have a legal control over the device. I'm very sorry to say that when I seen some part of my investigation, I have seen constables also signing Section 65B certificate, which they are not allowed to do so, because they are not in official position to do that. Number two, they don't have the legal control of the device as when the information was stored and when the information was being retrieved. So these changes or these provisions have to be known when the evidence is being produced in the court of law. Well, I have a shortage of time. One final question, and I think in next 3 minutes, all my panelist members should cooperate with me on that. I will go with Mr. Kotni, and that is, can a information or an output provided by ChatGPT be treated as an evidence in the court of law? What's your take?
We are all seeing ChatGPT all over the news. In the morning, I saw one AI application, Bhagavad Gita. You ask any question, it will tell you about life and all its aspects. Now, it is to be tested by the courts. Whatever it throws is evidence or not. But who is the best person to answer that? I asked this question to ChatGPT itself. Okay, what is the response of ChatGPT? Can I read it? 1 minute? Sure. It said, as an AI language model developed and maintained by OpenAI, I am not capable of producing original electronic records or physical evidence that can be used as evidence in a court of law. However, information retrieved from me can be used as hearsay evidence in a court of law, subject to certain conditions. Hearsay evidence refers to evidence that is based on the statement or representation of another person, rather than on the personal knowledge or observation of the witness. Under the Indian Evidence Act 1872, hearsay evidence is generally inadmissible in court, except in certain circumstances where the hearsay evidence is considered reliable and trustworthy. For example, if the information retrieved from me is based on publicly available data and is not challenged by the parties in the case, it may be considered as evidence under the provisions of the Act. In any case, it is important to note that the admissibility of the information retrieved from me as evidence in a court of law would depend on the specific facts and circumstances of the case and the interpretation of the relevant provisions of the Indian Evidence Act by the court. It is as if it's a lawyer's opinion. I mean, this is ChatGPT's response, which I got. The question you put to me, I anticipated and put it to ChatGPT. This is the answer. Thank you.
So I think you got the answer from Mr. Srinivas Kotni, what ChatGPT answered as far as the query which he had put across. Okay, I want to quickly ask Dr. Yende onto this. You have any opinion on this? No, okay. Anuj, any opinion on ChatGPT? Evidence, reports?
Usually, ChatGPT or any such platform is basically in the nature of opinion, and it is not at all in evidence. Now, if somebody is acting on whatever the opinion ChatGPT or things like that are giving, that has to be seen. That again has to be tested in the court. So typically, the answer is no to begin with, that whatever ChatGPT is saying is not an evidence.
Okay. Smith, half a minute.
Sure. I would just like to add, what I have seen in the new AI-driven cybercrime is just was going through GitHub. So there is a GitHub repo which says on a live CCTV, you can change the face. If let's say if I am a thief, I am going and I am picking up something, then with ChatGPT I can replace my face with Dinesh sir's face, and the entire thing can be done. So that's how the AI evolution is happening. So I see AI-driven cybercrime is going to play, and ChatGPT is just an enabler to it, basically.
Yeah, thanks.
Dr. DeCosta, I just want to add one point. We are talking about ChatGPT. Here we are in our session, we have a data scientist who has developed a ChatGPT. I just want to give a comment. For the discussion he has, what is your comment on
All right, so thank you, sir, for inviting me on this discussion. So I am Abhishek Kumar and I'm a founder of CyberRecon Private Limited. It is a cybersecurity startup. And we are building ChatGPT-like AI just for cyber threat intelligence. So my add-on that is, if a ChatGPT can give you links, hyperlinks, where those evidences are, then it can also be helpful in the court of law, right? So,
Okay.
so we are building the same tool. So this tool is actually going to scrape all over the internet, surface, deep and dark, and we are using state-of-the-art NLP algorithms, and then it is going to find out, so whatever entity you will put in, either it is a person or an organization, it will give you all the threat landscape of that organization in the form of live dashboards.
Okay.
So I believe this might be a revolutionary, basically AI fighting another AI, right? So, right.
Okay.
Thank you.
I think,
Thank you, Abhishek.
I think what you told across, I was there in one of the conference of the judges, and this matter came up, whether the AI can help the judicial system. And we are talking ChatGPT on the same terms. But outrightly, all the judges were in the same opinion what Anuj was, saying no. Saying no. That's what from the judges forum I'm talking to, right from the horse's mouth. The reason behind, because the system cannot decide the circumstances of any particular offense, because every offense has to be treated and decided differently. So there was a hearsay news which happened to come in the newspapers as well as on the internet, which says that the US courts are now heavily banking on these AI-based intelligence to decide upon the cases. Yes, yes. So there is a lot of particular things which has been floated and which is being said. But the Indian contingent, the courts in India still feel that it's very new, and I think it has a long, long way to go across. Okay, finally, a minute, I'll just sum up the whole of this particular, the panel discussions. The point what we raked across was in terms of the evidence, the viewpoint. Well, evidence can be treated in the court of law. It can be treated as a conclusive one, provided we have the provisions, the terms and conditions to be satisfied as laid down in the certificate. Point number 2, we also spoke across that whether the law enforcement agencies have to be governed with new information or technologies to be learned. The answer is yes. Do we require an internal forensic team to be placed? The answer is yes, to a large extent, because they can help in giving a quality evidence to the law enforcement agency, which can be tried in the court, and the justice can be given to the victim. And the last point, due to the shortage of time, and that is, we have very few electronic examiner labs in the country. A country which has almost about 29 states, we have only about 6 states in our country which has the electronic examiner labs. And therefore, under these situations, we require more electronic examiner labs to be developed, because unless and until the report from the electronic examiner labs doesn't come in the court, the defense always will say in the court that this evidence should not be relied upon. And therefore, under these circumstances, I feel so, under all the preview of my panelist members, I think the time has come that the government should start looking in for private agencies also under some strict guidelines, strict conditions, to be giving the momentum to them that yes, you can do this work under our supervision, and that will ensure that the crores of cases which are pending in the court can be decided upon quickly, fastly, and the justice can be given to the victims in a rightful manner. I thank all my panelist members for giving their viewpoints, and I certainly feel that all the august audience over here might have had a little more better view on the evidence and how the evidence has to be treated and what evidence can mean as far as a cybercrime is concerned. Thank you very much.
Thanks. Thank you for inviting.